So you make your case all the way up to the Supreme Court. There is a procedure of how things work. It's not like a regular court case where you have a jury on one side, you have people in the back. It's not like that at all. What's going to happen is that you're going to have both sides of the case, the two lawyers. They're going to come up and they're going to give oral arguments in front of those justices. Those oral arguments, however, are only a half an hour. So it's not like you have witnesses coming up to the stand. It's not like it's taking all day or potentially all week. It is half an hour per side. And within that half an hour, as they give those arguments, you have justices have the ability to then like stop and ask questions and ask for clarification. So even that's all within their like half an hour. So they can be interrupted by that. When they are then afterwards, like when they're talking about it, when they're conferencing, the justices are conferencing, trying to figure out who's in the right, who's in the wrong, what's the majority, what's the minority, what's the overall decision. What's going to happen is that there's sort of seniority in who speaks first. So the Chief Justice will be the first one to actually speak on it, and then after that, it'll go by seniority on who actually gets to speak and when they get to speak and give their sort of say. Before those oral arguments are given, the Supreme Court justices will be given briefs, and those are written documents detailing the arguments in those cases. So those briefs will be sent up before those oral arguments are given, and the justices have those to look over and glance over before the court case is actually given. And there's still also like requirements and restrictions on when that court case can be heard. Justices only meet Wednesdays and Fridays, and when they do, like when they meet, they hear those cases, and only a third of those cases actually have a unanimous decision, meaning everybody is going to agree on that one decision. An example would have been like Brown v. Board of Education, in which they said that the segregation of schools was unconstitutional. That was a unanimous decision. All 9 justices agreed on that one decision, and so 1/3 of cases have a unanimous decision, but a majority of cases are usually split. So this could be like a 5-4 split. This could be like a 6-3 split. And so when you have like a 6-3 split, 6 justices agree to one side, 3 justices agree to another. You have a majority and you have a minority. So majority would be that 6 people agreeing, since that's the majority, and that would be the overall outcome of the case. So like majority wins. So that's the outcome of the case. And so you would have one person from the majority. They would write the majority opinion, and that's sort of like a brief description of what the outcome is and why they agree to it. So this could pull from previous cases. This could pull from constitutional laws, constitutional amendments. And then you also have concurring opinion. So you can be a majority and also have a concurring. You can agree with the overall majority opinion, but disagree with why they agree to it. So that would be concurring, when you agree with the decision but not with the reasoning. And so you would also have someone who would write that concurring opinion, sort of detailing why they think differently. And then, of course, if you have a majority opinion, you'll have a minority opinion, also referred to as a dissenting opinion. And this is the minority group. So in that 6-3, the 3 would be that minority, and so they would write a dissenting opinion. However, later on, a minority opinion or dissenting opinion could potentially become a majority opinion in a later case. So again, going back to the example, Brown v. Board of Education, before Brown v. Board, you had Plessy v. Ferguson, which the Supreme Court said that the separate but equal doctrine was okay, that you could separate as long as you had that quote-unquote separate but equal amenities. However, down the road, you're going to again see that Brown v. Board of Education, and the Brown v. Board of Education, like that minority decision in Plessy v. Ferguson, then becomes a majority opinion down the road. So you do see that change that has taken place. And so part of that is these Supreme Court cases set a precedent. The Supreme Court rules and all these other courtrooms underneath it sort of have to follow what that Supreme Court said, like what that Supreme Court outcome was. It's that precedent. So an example of this would be Roe v. Wade on abortion. The Supreme Court heard a court case about abortion. They then decided on the when you can have abortion, what circumstances you can have abortion, and now all of the other lower courts throughout the United States and throughout all of the other individual states, they now have to follow that precedent. So, the example to be followed in future decisions by the court.